Hi everyone, this is Mr. Zoeller, and today I'm going to be bringing you a screencast on our third branch of government, the Judicial Branch. So before we get started, I just want to remind you that remember our very first government, the Articles of Confederation, that there was no executive branch and there especially was no judicial branch. And so one of the major weaknesses, there's no courts, so there's no one to decide um, if a law is right or not, and if there's a dispute or an issue between the states. So under the Articles of Confederation, each state had its own courts and laws. However, there wasn't a United States courts or a judicial branch under the Articles of Confederation. So that's one thing that we wanted to fix in the Constitution. So in the Constitution, we can find the Supreme Court and the judicial branch in Article 3. So in Article 3, we have the creation of the Supreme Court, which is our highest court in the United States. And then the Constitution also gives the Congress the power to create inferior courts, which are basically like courts underneath the Supreme Court. And so we're going to see an example of that with the Judiciary Act of 1789, which created our federal district courts, which is our lowest level of courts. And then later in 1791, we'll have the appeals courts that were created. So the federal courts are at the bottom, the appeals courts are kind of in the middle, and the Supreme Court is at the top. So there are two different court systems in the United States. So we have federal courts that involve United States laws and state courts that involve state laws. A vast majority of court cases that take place in the United States are going to be done at the state court level. So if your parents ever received a jury summons to be on jury duty, most of the times they're going downtown to Truxtun Avenue, and they're going to be going into a California courtroom. So most laws we have here in California that people will get arrested for or put on trial for are state laws, and so you would be tried in the state court for that. And then if it's a violation of a federal or United States law, you would go to a U.S. court. So there's two different types of cases that are heard. So first are criminal cases, so cases in which juries decide whether people have committed crimes. And then we also have civil cases in which two sides disagree over an issue and you have lawsuits. So like if you watch the Judge Judy show, those are going to be civil cases. For jurisdiction, so what powers do these courts have? So for federal court jurisdiction, jurisdiction means the authority to hear and decide a case. So federal courts have jurisdiction in the following areas. So anything involving the Constitution. So if a constitutional right has been violated, so if somebody is arrested for their religious beliefs or their freedom of speech, that is something that the federal courts would be hearing. And then if it's a violation of any laws, federal laws and crimes like kidnapping, bank robbery, etc., those would also be tried at the federal court. Any crimes on the oceans, out on sea, involving maritime laws, and would also be under the federal courts. And then if two or more states have disagreements on laws and how they're treating one another, then that would be something that the federal courts, the United States courts, would end up hearing. Let's take a look at our very first lowest level of our federal courts, which is the district courts, and this is created by Congress. So this is the lowest level of the federal court system, and this is where trials are held and lawsuits begin. And they have what's called original jurisdiction, which means they have the authority to hear a case for the first time. So this would be kind of like a typical trial you would see on TV, but if it was for a violation of a U.S. law, so you'd have one judge, you would have a jury, they would listen to the evidence that's presided, and then they would make a decision whether that person is either innocent or guilty. And so since this is the first time that trial has happened, this court is known as, this is where original jurisdiction takes place. So only federal court is where jury trials are held. So when we get to the appellate courts and the Supreme Court, there are no juries. And then each district is a geographic area. So if you are committing mail fraud, income tax evasion, bank robbery, treason, etc., you would go to a specific district court based on where you lived, or where the crime was committed, I should say. And then for the different types of cases, so for civil cases, disputes involving labor relations, public lands, copyright, patent laws, civil rights, those would be civil cases. And then the Constitution states that such trials shall be held in the state where the said crime shall have been committed. So if a U.S. law was broken in California, it would take place in the district court that covers that area. If it took place in Missouri, it would take place in that district court. So you're not going to go all the way across the country to another district court. when you violated a law in a particular state. And you can take a look down here at this map. So like right here in California, each of these little sections is a district court. And so since California has so many people, the highest population, we have 4 district courts in our state. And you can see some other ones. There's at least one per state, but California has 4 of them. So the next step above the district courts is now the U.S. Court of Appeals, or the appellate court. So they have what's called appellate jurisdiction, which means that they have the power to hear a case which has gone to the district court or through federal regulatory agencies, which basically means that, let's say you were put on trial in the district court, you were found guilty, you feel that your rights have been violated, that you're not guilty, you have the right to ask the higher court, which is the U.S. Court of Appeals, to appeal your case, which means they have the power to hear your case and either confirm with the lower court's decision, or they could change it. So it can only be used if this law was not followed properly, or procedures are not followed properly. So if the police didn't collect the evidence, or the trial didn't go well, or they violated your rights, then the court could hear it. And then this is created to ease the work of the Supreme Court, so the Supreme Court doesn't have to hear so many cases. And so you can see on here there are 12 circuits or geographic areas, in Washington, D.C., which is right over here, has its own. That's where the 12th one's located. So if you were found guilty at, let's say, our district court, which actually meets in Fresno, California, and you asked the U.S. Courts of Appeals to hear your case, that would be the 9th Circuit Court, which is up in the Bay Area. And so they represent all of these different states. So the district court's the lowest level. If you appeal it, it goes up to the appeals court. And then the final court, that's going to be at the top, is going to be, of course, the U.S. Supreme Court. There are also some special federal courts depending on what laws are violated. So you have the tax courts, you have federal claims for government money claims, military, so for the armed forces, and then international trade going on with different businesses and things like that. So for the top court of the judicial branch, we have the United States Supreme Court in Washington, D.C. It's right across from the Capitol building where the Congress meets. And so they have some original jurisdiction, so there are just a few cases that they would hear originally that wouldn't go through the other courts. So they preside over trials in cases that involve diplomats from foreign countries, and they preside over trials where states sue each other. But usually the Supreme Court allows the lower courts to hear things like that. They also have a really important power. This is something that you really need to know. It's called judicial review. And so the court may review any federal or state law to see if it is in compliance with the Constitution. So this is one of the most important powers of the Supreme Court. And if the Supreme Court says that a law is in conflict with the Constitution, they'll say that that law is unconstitutional, which means it needs to be nullified or canceled out. So if California passed a law and it stated that all Californians must worship Optimus Prime, so we're going to be Autobots, I guess. We're going to follow the Autobots. The U.S. Supreme Court could hear a case where somebody's suing, saying California doesn't have the right to force us all to follow one religion. That violates my First Amendment right to freedom of religion. If the Supreme Court took that case and they ruled in favor of that person, saying yes, that state of California violated everybody's First Amendment rights, then that law would be nullified, or it wouldn't be followed in California. And so the Supreme Court is kind of like the referee. It makes sure that the legislative branch, the executive branch, and the states are following the Constitution. So when an issue comes up, they have the final say on it. And so the Supreme Court's going to get this power from a famous Supreme Court case in 1803 called Marbury versus Madison. And just to kind of sum up basically what happened, John Adams, it's his last night in office before Thomas Jefferson takes over as president the following day. And so he adds a few more judges to the district and appeals courts. And so we're going to have Marbury, who's been appointed to be a justice of the peace, but President Jefferson ends up telling him he can't have that job. So he ends up going to the Supreme Court asking to get his job that he should have had, and he's citing the Judiciary Act of 1789. So the Chief Justice, who is basically like the head judge on the Supreme Court at this time, was John Marshall, and he wrote the majority opinion turning down Marbury's claim. And he said that judicial review has a couple points to it. First is that the Constitution is the supreme law of the land. So no state and the United States government cannot create any law that violates the Constitution. And then when there is a conflict between the Constitution and any other law, the Constitution must be followed. So that's why it's supreme. It's the top law. And then whose job is it to make sure that the states are not passing laws that violate the Constitution, or that the U.S. government isn't passing laws that violate the Constitution? That is the judicial branch. That is, at the end of the day, the U.S. Supreme Court. And so the judicial branch has the duty to uphold the Constitution and nullify or cancel any law in conflict with the Constitution. So this power is called judicial review. So the Supreme Court can review laws and actions of the legislative branch, the executive branch, and the other states. And if those actions violate your rights in the Constitution, the courts can tell the other branches to stop. So taking a look at our current U.S. Supreme Court, so we have there are 8 associate justices. So when you're on the Supreme Court, you're no longer a judge. You have the title of a justice, and then there's one Chief Justice, like the head judge. So here's a picture of our current U.S. Supreme Court. So Justice John Roberts right here is the current Chief Justice of the Supreme Court. So there are no set formal qualifications or set number of justices. So there's no age requirement like the Congress and the President. There's no citizenship requirement. Now, informal qualifications, which means it's not in the Constitution, but so far what have kind of been the qualifications to be on the Supreme Court, every single justice in our history they have been lawyers, and most of them have been judges, and many have served in public office in different states. And then just kind of a special note, William Howard Taft is the only Chief Justice of the Supreme Court who has also been president. So he was president first, and then after he was done being president, he ended up being a Chief Justice on the Supreme Court. So kind of interesting little tidbit of history there. So how do you get on the Supreme Court? Well, you're not elected. You're going to be appointed by the president, and then you have to be approved by the Senate. So right now, if there was an opening on the Supreme Court, President Barack Obama would nominate or appoint somebody he wants to be on the Supreme Court, and then that person would have to go in front of a panel of the U.S. Senate and be kind of grilled for like 1, 2, or 3 days, just like a huge job interview. And then the U.S. Senate has to vote in favor of that person to be on the Supreme Court. So the president usually tries to appoint people to the Supreme Court who share the same ideology or beliefs. It's like for President Barack Obama, who's a Democrat, he's usually he's put 2 justices on that have similar beliefs in the law as he does. Versus George W. Bush, who was before the president, he put on 2 justices that had similar beliefs to him. Once you are approved by the Senate, and now you're on the U.S. Supreme Court, you get to have that job for life. So you can have that job as long as you want. You're not reelected. You're not tied to any political party. You don't have to worry about running for reelection. And so justices can stay on for as long as they want until they resign, or they can be impeached, which means that if a justice on the U.S. Supreme Court is suspected of violating a law, they could be put on trial, and if they are impeached by the House and found guilty by the Senate, then they'll be removed from office. And then the president will have to appoint a new justice to go on to the U.S. Supreme Court. All right, well, that's all I have for you guys. I hope you enjoyed this video and learned more about the judicial branch. Make sure to fill out your notes, and I'll see you guys later. This is Mr. Zoeller. Bye-bye.